aspects of law and the legal system and the lawmaking process. Rights of the defendant to legal representation. You get the right for financial help. Community Legal Services, CLS. This is here to help people with civil matters such as compensation. You can apply for help. Only a limited amount of money is given. When this runs out, you may not get assistance. You can also get Criminal Defence Service, which is CDS. This is legal aid. All those involved in criminal proceedings have the right to advise, assistance and representation. All police stations have a duty solicitor provided by the CDS. Representation. This covers the cost to prepare and represent the client, usually in the magistrate court. It may also cover the costs of a barrister at Crown Court and cost of appeal. Bail. Bail means you are freed from police custody until the next stage of your trial. Police bail. Bail can be given if a person is being charged with an offence. It can also be given if no charges are brought, but the investigations are ongoing. Bail is granted by the custody officer. After a suspect has been charged, the police must release him or her on bail unless there is a doubt about the suspect's name and address. The police feel that the suspect may interfere with witnesses or evidence. The police feel that the suspect needs protection or someone else needs protection. The police feel that the suspect will not attend court. Police can't just arrest anyone, they have to go to the magistrate court. Normally it will be the Defence v CPS, which is Crown Prosecution Service. Often bail applications will be heard at pre-trial before a presiding judge. Conditional bail. Police can impose certain conditions on bail. Surrender of passport, reporting to police station at fixed time, curfews, which is tagging. Unconditional bail. This is bail given without any conditions attached. Criminal trial process for both the summary and indictable events. Summary offences. Summary offences are offences that are seen as minor and will be seen by magistrates rather than a Crown Court, meaning the accused will not have a jury. An example of a summary offence is the drunk and disorderly legislation. This will be seen in the magistrate's court, and most of the people accused will end up just with a fine. Indictable offences. An indictable offence is more serious than a summary offence and requires a trial by judge and jury. An indictable offence cannot be heard in the absence of the defendant. You are guaranteed the right to a fair trial by the jury, whether you plead guilty or not guilty. Some examples of an indictable offence are aggravated burglary, indecent assault, drug trafficking offences, murder and manslaughter. Trial process for summary offences. The court clerk will ask the accused their name and address. When an individual is facing a summary offence, the trial process begins with the clerk reading out the charge and asking whether they plead guilty or not guilty. If they plead not guilty, the case will be adjourned for trial. This is to give the prosecution time to get the witnesses to attend the court, as well as enabling them to prepare their case for trial. Pleading guilty. If the offender pleads guilty, then the magistrate could automatically give them their sentence the same day. This could be a fine or even a prison sentence. When the case gets sent to Crown Court, firstly the court will have a plea and a case management hearing. The court then have to make sure that the correct steps have been taken in preparation for the trial, as well as the trial date being set. After the defendant will then enter the plea, pleading guilty. If the defendant pleads guilty, they can then give the sentences straight away. The defendant could also request for trial to be adjourned. Pleading not guilty. If the accused pleads not guilty, the prosecution and the defence have to inform the court of reasons why. This has to include the issues in the case, number of witnesses, as well as the order in which the prosecution witnesses will be called. Any formal administrations, exhibits, the order of paging of papers to be used by the prosecution at trial, and at any point of law or question as the admissibility of evidence which is expected to arise. A questionnaire is completed by counsel for each party to inform the court the estimated length of trial and when the witnesses are available. Sentences powers of the magistrates. The magistrate court can give the sentences such as prison sentence for up to 6 months. They can also give up to a 12-month sentence if the accused have committed a crime more than once. The court can also give fines up to £5,000 and a community sentence or combined sentences such as fine and community service. An example of the type of sentences they will give is if someone was to commit a driving offence such as speeding, the magistrates would more than likely just give a fine to the accused as it's a minor offence. In some cases, a magistrate's court can decide that the accused should be sentenced to more than 6 months. If the court occurs, the magistrate will then pass the case to Crown Court. They will decide the sentencing. Sentencing powers of the Crown Court. Unlike the Magistrate Court, the Crown Court do not have the limit to what sentence they give. The Crown Court can give sentences and also prison service. The Crown Court can also do not have a limit of how long they can sentence someone. For example, someone was commit 6 counts of murder. The accused can be given life in prison to which they will spend the rest of their lives in prison. An example of where this has occurred is the Ian Brady and Myra Hindley case. Triable either way offence, a crime that may be tried either as an indictable or a summary offence. Such as crimes that include offensive deception or fraud, theft, bigamy, and sexual activity with a child under the age of 16. The trial process for a triable event, either offence, starts with the defendant being asked if they plead guilty or not guilty. They lose the right to ask to go to Crown Court if they plead guilty, but the magistrates can decide to send them there for fair trial. If they plead not guilty, the magistrate will have to complete a mode of trial to find out where the case will be heard. Trial process. The magistrate court must consider the seriousness of the case as well as their own power and punishments and relevant for the case. If a case includes any sort of complex questions of fact of law, it should be sent to the Crown Court for trial. Also, if there was a breach of trust by a person or the crime was committed by the organised gang, they will also be sent for trial at Crown Court. The only way a defendant can choose if they was to be tried by the jury or tried by magistrate is if the magistrate accepts jurisdiction. If they was to choose the magistrate and found guilty, they could also be sent to Crown Court for further sentencing if the magistrates believe that their punishment is not strong enough. An example of this is if an example of this is assault. The defendant could be sent to the magistrates but could then end up being sent to Crown Court for sentencing because after the facts heard by the magistrate it could be progressed into GBH. Grounds of appeal. You have to have a right to appeal against decisions of the magistrate court. If you were found guilty after a trial, you can appeal to the Crown Court against your conviction. However, if you pleaded guilty and were sentenced in the magistrate court, you will not be able to appeal against your conviction, but you can still appeal against the length or nature of your sentence. You must provide the prosecutor with your notice to appeal against your conviction or sentence within 21 days. It is possible to apply to Legal Services Commission for legal representation at your appeal. The Crown Court will give you a date when you must attend for your appeal, which will be heard by 2 magistrates and a Crown Court judge. There is no jury, but your entire case will be heard again. If your appeal is against sentence only, the prosecutor will tell the court details of your conviction, and you and your lawyer will then tell the court about your personal and financial circumstances, if appropriate, and mitigate in relation to the offence itself. If your appeal is against conviction, the witnesses who gave evidence at your original trial in the magistrate court will be required to give evidence again. However, it is important to note that, as well as questioning a conviction and reducing a sentence, the judge and magistrate are entitled to impose a harsher or different sentence and may also make you liable to pay the prosecution costs if they consider that you shouldn't have brought the appeal in the first place. There is no further right of appeal after you have appealed to the Crown Court or from the magistrates.